Well, legal analyst Benedict Phiri joins us now for more on this discussion. Welcome. Thank you so much, Benedict. Firstly, is it at all uncommon for an application to appeal a decision based only on an order and in the absence of a judgment?
It's not uncommon. It's obviously not what happens all the time, but certainly, it is common for an order to be appealed, especially when the matter is urgent, as it is in this particular case, before the reasons are given for the judgment. And certainly the IEC would feel that the matter is quite clear, and whatever the reasons may be, the court got it wrong insofar as how they interpreted Section 47. So it's not uncommon, but it is not what happens frequently.
And given the wording of the IEC statement, does it seem valid that clarity is given on the interpretation of Section 47 and its interplay within the powers of the Commission to adjudicate objections to candidates?
I think it is valid. I think what the court has done with this order is it's made it unclear whether the IEC can adjudicate an objection to a person's candidature to the National Assembly. Certainly the way that the Act operates and what the powers of the IEC are, it has always occurred to me or seemed to me that the IEC would have the powers to adjudicate that objection because that's what they're given under the Act. So I think it is important for the Constitutional Court to clarify who has the ability to disqualify a person who's running for the National Assembly on the basis of him being convicted of an offense, which is for a period over 15 months and without the option of a fine. I think it is important that the Constitutional Court clarifies exactly who can deal with that objection. I would say that it's probably the IEC, but I think it is an important conversation given that the order has left it unclear whether that sits with Parliament or the IEC.
This leads me to the next question, Benedict. Does it appear that the IEC is certain that the Court could rule differently?
I think there's good chances that the Court could rule differently. I don't think the matter was as clear-cut as the order makes it seem. Certainly there were good submissions made by the IEC on why Section 47 should be interpreted in the manner where, you literally look to the fact of the conviction and you look to the fact of the period of the conviction and whether that person has actually sat out the mandatory 5 years before they could be eligible to the National Assembly. The MK party and Mr. Zuma also made clearly what were persuasive submissions to the court now around the fact that, that remittal made Mr. Zuma, it basically qualified Mr. Zuma. But I think, the IEC is in a good position insofar as this appeal is concerned if it deals with those aspects.
So while the IEC has made it clear in their statement that they urge the Court to decide on this matter before the 29th of May, is it probable that a ruling could be made before the elections?
One would hope so, because electoral matters must be dealt with urgently insofar as the legislation is concerned. And we've seen even in the matters that have gone through the Electoral Courts, the MK matter, as well as this particular one around the objection to Mr. Zuma's candidature for the National Assembly, that they have been dealt with in an urgent way. And I'm glad that the IEC did bring the application on an urgent basis. And I would hope that the Constitutional Court can deal with that application before the elections.
Well, thank you so much for providing that clarity, and thank you for your time. That was legal analyst Benedict Phiri.